Thank you, Mr. Chairman. My name is Dr. Robert Anderton. I'm a practicing dentist and attorney. I'm a former president of the Dallas County Dental Society, the Texas Dental Association, and the American Dental Association. As an attorney, I represent a large number of orthodontists, pediatric dentists, general dentists, Dr. Paul Dunn, several other dentists and orthodontists who are here today. Many are involved in the current Medicaid pre-authorization dispute and the many controversies regarding allegations of Medicaid fraud and payment hold. I think from hearing what I've heard today, probably I'm in a good position to maybe clarify some of the things that have happened and some of the things that we've heard today, particularly regarding Dr. Dunn and some others. First of all, the district court issue, to address that, I mean, it's not as if we haven't tried. Along with Mr. Canales and Mr. Garcia and Tony Goodall and other attorneys, we have been to district court 3 different times on different issues regarding the payment hold and the OIG investigative issue. But we've been turned down every time because we've not exhausted all of our administrative remedies. So that avenue is not open to us, so that's why I'm speaking in favor of 1536. Eventually, hopefully we will be able to get there. But, and again, to go back to Dr. Dunn, if I may, Dr. Dunn was reduced from 100% payment hold down to 51% payment hold. And what happens in those cases, they go back and once these cases are extrapolated, they come up with a big spreadsheet called Exhibit A. And this has all of the allegations, as Mr. Stick has said, some with claims, some with money, some with standard of care issues, and a big spreadsheet with their experts' opinion on that spreadsheet. And it's sent back, and they come up, extrapolate, and come back with these huge error rates. And usually they're in the 80 to 90 to 98% error rate, as Mr. Stick says. Well, at that point, when we get that spreadsheet, and we haven't seen the spreadsheet from Dr. Dunn yet, but when we get that, we'll go back with our experts, and our experts will go over those spreadsheets, and we come up generally with an error rate somewhere in the 4 to 5% range. So there's a big difference, and it's going to boil down to expert opinions. So if we ever get to the SOA court where we can put this in front of the judge, we feel like that we're going to prevail in many of these cases. But in the meantime, we've got this huge payment hold to overcome. So my purpose here today is fourfold to appear before this committee. Number one, I'm here, of course, to support the passage of House Bill 1536 and to urge the Executive Commissioner on Health and Human Services to apply the current law found in 42 CFR to provide relief to these doctors who are being forced out of business because of the oppressive results of the payment hold. I also want to urge the Executive Commissioner of Health and Human Services to adopt a policy or a rule which requires that a fair hearing on any payment hold be scheduled within 30 days, and to provide information regarding Medicaid beneficiaries and the current status of the doctors who are on hold, and the tens of thousands of the underserved children who we're trying to take care of in this program. There hasn't probably been enough said about those children, but I will address that, of course, later. If allowed to go into effect, of course, House Bill 1536 will take effect in September of 2013, and will apply to all the cases that come in after that. However, the providers who are currently under investigation and are on payment hold need help immediately in order to continue to serve these Medicaid beneficiaries. And that we can get some help for them. And of course, federal regulation 42 CFR mandates that the state Medicaid agency must suspend all Medicaid payments to a provider after the agency determines there's a credible allegation of fraud. And based on this provision, after the Texas OIG conducts an investigation and alleges fraud, without a hearing, a payment hold of 100% of a provider's funds is put in place with notice after the fact. The 100% hold then remains in place virtually indefinitely unless the OIG determines that the amount can be reduced, or the provider can prevail at a hearing on the merits of the hold, or at a hearing on the merits of the entire case. Now, if allowed to remain in place for any length of time, 100% payment hold is fatal to the dental practice of most providers. Even if reduced to 50%, like in Dr. Dunn's case, the practice overhead nearly at 70% or more practices can't survive. And in spite of assurances from OIG that there's absolutely no intent to put anyone out of business, just within the last month, a large practice in North Texas was placed on 100% payment hold. The practice was forced to lay off 117 personnel and cancel or postpone 40,000 dental care appointments for Medicaid children. Now, that's a lot of kids. Other practices have been forced totally out of business, and others yet have been forced into bankruptcy. I'm going to a hearing next Friday on a case where the doctor was put on 100% hold. His hold was generously reduced down to 89%. OIG wants to recover $11 million. The doctor declared bankruptcy. We're going to go to a hearing with the Attorney General's office to see what we can salvage for this poor doctor. Now, there is relief in 42 CFR again, which provides that the state can determine that payment suspension in whole or in part is not in the best interest of the Medicaid program. Now, we haven't talked about that provision that's in 42 CFR. This can be put in effect with merely a policy change or an executive order from the HHSC executive commissioner. The executive commissioner could immediately implement, first as a matter of policy, and later by rule, a requirement that a fair hearing on any payment hold be scheduled at the State Office of Administrative Hearings not later than the 30th day after the date the payment hold is imposed, unless the provider requests a continuance. Well, as we mentioned, there are other vital interests here, the Medicaid beneficiaries. My firm represents well over 100 dental offices, orthodontic, general dentistry, and pediatric dentistry all across the state. These offices, most of them are under investigation or have been placed on payment hold. They have currently in treatment over 100,000 Medicaid kids. As noted above, just within the last month, 40,000 appointments were directly affected by this 100% hold, placed without a hearing again and without prior notice. It also affected 117 people who lost their jobs. Now, recognizing that there are no quick answers here, I'm urging this committee to consider some possible immediate action. One is a modification could be placed on the 100% recoupment hold. The doctors are forced by these holds without adequate compensation to continue treatment to avoid abandonment issues. Once the doctor goes out of business, we have to figure out a place to put these kids. I spend a good deal of my time trying to find the doctors who will take these kids once the doctors go out of business. We've had several, probably 10,000 of those kids that have been affected, but we have so far been able to find doctors who will take them. I don't know how long that will be. But again, the program is in jeopardy if these doctors are continued to be forced out of business. The 100% payment hold could be reduced after a maximum period of, say, 2 weeks to a manageable amount, say 10 to 20%, pending an expedited hearing or other final disposition of the allegations. Again, the 100% level or otherwise could be scheduled at a fair hearing at the State Office of Administrative Hearings not later than 30 days after the day the payment hold is imposed. Number two, doctors who have been approved as providers in the program, even though they're under investigation or have a disciplinary history with the Texas State Board of Dental Examiners, should be excluded, should not be excluded, merely on the basis of these disciplinary actions, but they should be allowed to continue. The MCOs are not consistent in the approval process. One will approve a doctor and one will not. Many of these doctors are major providers in their areas, which are often highly underserved. And lastly, representatives from the private dental practicing community and the dental service organizations should be included at the table as stakeholders in future negotiations regarding program rule and policy changes. Input from those who actually treat Medicaid patients is invaluable in formulating policy and program rules. Thank you for your time and attention to these critical issues. I know that this committee, HHSC, OIG, TMHP, and MCOs, the providers, all have a vested interest in this program, especially in providing the care that these kids need. I'll be happy to answer any questions that you may have.
Thank you, Doctor. Members, any questions? Thank you, Dr. Anderton.
Thank you.
Appreciate it.